Hi, Bill Henshaw here again, your walking constitution and another timely update. And this one's on a very recent decision by the 9 Parts, aka the U.S. Supreme Court, U.S. v. Madero. And I read this, and as you know, if you've been following my videos, this has been going on for the last year and a half, that they're starting to act like a judicial court for the first time in 90 odd years, and maybe longer than that. That said, this decision, they do a significant study of the insular cases. For those of you who don't know, back in the late 1890s and early 1900s, cases involving issues arising in federal territories, federal insular territories like Cuba, Puerto Rico, Guam, the Philippines, places like that, where the court effectively ruled that people in those jurisdictions had no rights the de facto national socialist government is bound to respect. And that's the situation we face. And in fact, for quite a while, I realized reading these cases, if you don't know what you're reading, you might be confused, and think that you're reading a case out of, for example, California, where I am, or any other alleged state admitted into this union. And indeed, some of these insular cases cite a case called Hurtado v. California, 110 U.S. 516, a real BS decision they made, and Hurtado correctly claimed that California couldn't proceed against him without a grand jury indictment. Simple. If all process issues in the name of the people of the state of California, yet they're specifically excluded from the process, and that remains true today here and in your jurisdiction as well. They have no jurisdiction. There just isn't anything there. And the court not only did this and effectively did away with these insular cases, they did it using exactly the same references I use. Hell, I thought I would never see this day. And these are sterling, they're platinum references that talk about the insular cases and what went on then. And it goes as far back as American Insurance v. Canada in 1828, I believe. And here again, if they're ready to rule on the limits of Congress's Commerce Clause powers, and you go another 9 yards here and take care of this nonsense with insular territories, we're in really good shape here. This is the battle raging behind the scenes, in my view, and it has been for at least a year and a half, what with the Biden court packing plan. That said, send me an email, uwinnincourt@gmail.com. I'll get you information out on what I do, how I do it, and my modestly priced materials. And you can start going in there and invoking your rights, and we start telling them what to do. After all, this is a principal and agent relationship. We tell them, not the other way around. Wouldn't it be nice to get back to that in our Republican form of government, that we're supposed to have defined and limited powers guaranteed by Article 4, Section 4? Long overdue, but we can get there, and I think we have an unprecedented window of opportunity to do it across the board here. I really do. So that's why it's exciting. And, well, for me, I'll be 74 later this year. My life is still ahead of me because of the work I do here. Got started rather a bit late. They didn't teach me a damn thing in high school either 50 years ago, but better late than never. And I want to pass it on to you and your family. Send me an email, uwinnincourt@gmail.com, and we'll take care of that bit of business. And you're going to love absolutely all of it, because now we not only have a lot of leverage, it's their bosses in Washington, D.C. saying it clearly and unequivocally. That's the great part of what I do here. And it's just been a long time coming. But we're on the precipice here. We can take it back and get our government back. It was never perfect, but it's a hell of a lot better than the one we have now. Federated Republican form of government, not the democracy. 3 wolves and 2 sheep voting on what's for dinner. That's never worked, and it's never going to, even on a local level. So like I say, it's exciting times, and send me an email, uwinnincourt@gmail.com, and I'll be happy to send you at the moment lightly annotated version of U.S. v. Madero. and it will make some sense to you. I'm going to do a much better job of it, and I'll follow up with a more annotated version. But when you see what's going on with the U.S. Supreme Court, and this one, by the way, was 8-1, not 5-4. 8-1. Only Sonia Shithead was the only one that dissented from this. And if that trend continues on the Supreme Court, we're really in good shape. They're finally starting to understand not only what's going on, but the sworn duty they have to take care of business. As per Cohen's v. Virginia, you'll learn all about Cohen's. Send me an email, uwinnincourt@gmail.com. And remember to get out there, tell your friends, like the videos, subscribe. And remember, we all have to work together here and cut out this divide and conquer BS they've been doing for way too long. Right issues, right courts, right results. Thank you.